Good afternoon, ladies and gentlemen. Welcome to the last panel. I think it might be the easiest one, thinking about my picture that is so relaxed. So I really will try to bring that smooth look into our conversation. Of course, we have a lot of questions. This is a hot topic these days in arbitration. I already told my panel that although I'll be moderating, I have a lot of questions that I want answers, of course. So without further ado, we will start our panel on climate change and ESG disputes. So basically, there has been a raise of disputes related to climate change, human rights, and governance. So in a nutshell, we are talking about ESG. The fact that the public and consumer scrutiny on business activities led to an exponential rise of these disputes, and it proves that no one is too big to fail, seems to be also in the hands of the public as part of democratic systems, the accountability of business and consumers taking an active role on environment, human rights, and governance issues. Some articles state that the term environmental, social, and governance, ESG, was first coined in 2005 in a landmark UN report entitled Who Cares Wins. From there until now, from Kyoto to Paris, ESG is a powerful tool in the hands of governments, businesses, and the people in general. On the other side, investors are shifting their portfolio into sustainable businesses, not just for ticking the boxes, or maybe just for ticking the boxes, but also to assure profits that guarantee or protect our future. At this panel, we will discuss this type of disputes, bearing in mind that although our topic is disputes, we are also at a panel of an arbitration event. So what we will want to know is that at the end of the road, is arbitration suitable for ESG disputes? So I will start introducing my panel, and afterwards each one of the members of the panel will discuss different parts of this type of disputes. ESG disputes in international arbitration, climate change disputes and international arbitration, arbitration and governance or shareholder ESG disputes, and ESG disputes and 5 challenges for international arbitration. I will now pass on and start the introduction of my panel. I will start with, well, I was supposed to start with Conway, but I will start with John Twidwell. I'm sorry if I'm saying wrong your name, who will be the first intervener. John is a partner in the London office and co-head of international arbitration practice at Eddleshaw Goddard. John has over 22 years of experience advising on international commercial disputes and has acted as a counsel for multinationals, banks, and governments in international arbitrations under most arbitral rules, including arbitrations under the LCIA, ICC, ICSID, and others. John is a solicitor on civil proceedings at the Supreme Court of England and Wales and has substantial experience advising on proceedings in the Commercial Court in London. Sectors and industries in which he has particular knowledge and experience include energy, oil and gas and renewables, life sciences, pharma and biopharma, manufacturing and engineering. We have a lot to hear from John today. I will afterwards introduce Conway Blake. He's a partner at Deborah Weiss and Clinton. Conway is also a member of the of the firm's International Dispute Resolution Group based in London. Blake represents corporate clients, sovereigns, and international organizations on a range of contentious matters, particularly in investor-state arbitration, public international law disputes, and commercial arbitrations governed by various substantive laws and conducted under the major arbitral rules. He is actively involved in the public international law and arbitration communities and has been recognized as a future leader in international arbitration by Who is Who Legal 2022. Dr. Blake, if we can say, is recommended by Chambers UK 2024, where he has been described as a star in the making and a brilliant mind. He is also recommended by the Legal 500 UK, where clients describe him as a fantastic legal strategist and a great communicator. I will now introduce Alison MacDonald, King's Counsel. And I believe she must have gone through some hurdles to change everything, documents from QC to KC. Nevertheless, Alison has an extensive practice in public international law, arbitration, human rights, and criminal law in both domestic and international courts and tribunals. She is described in the legal directories as one of the smartest, most charming advocates at the bar, with killer litigation instincts. And I really love this. And as an intellectual giant who works incredibly hard and is very cool under pressure. Clients consider her to be a superstar, a brilliant oral advocate who performs exceptionally well before the most prestigious international courts and arbitral tribunals. Well, one of my biggest interests, and I don't know if Grace will be able to speak about, is one of the cases of recent cases that Grace has in her hands about a group of Portuguese children and young people in groundbreaking climate change litigation in the Grand Chamber of European Court of Human Rights against Portugal and 32 member states. As I recall, this was one case related to the fires in Portugal that happen every year, and many families have been losing, well, properties and members of the families. And finally, but not least, I will introduce Arthur Parente. He's a partner at Matos Filho, where he focuses on international and domestic arbitration, litigation, and pre-litigation negotiations involving M&A, securities, and commercial disputes. He regularly advises shareholders, boards of directors, and executives on corporate governance conflicts, drawing on his extensive experience as a corporate lawyer in corporate and M&A transactions. He has also practiced at Freshfields in Paris and Boyce Schiller Flexner, I hope I'm saying correctly, in New York. He founded and presided over the Columbia International Arbitration Association in New York. He holds an LLB from the University of Rio de Janeiro and an LLM degree from Columbia Law School. Amongst his recognitions, Arthur was considered a Latin lawyer in arbitration in 2023-2024, Leaders League, and from the Legal 500, the Next Generation Partner and LATAM Arbitration Power List. So I won't take more time from you and from my curiosity, and we'll start with John.
Thank you, Itueva. What I'm going to attempt to do over the next 15 minutes or so is to help frame our discussion by looking at the current landscape in terms of identifying the different types of ESG dispute that we're seeing. And that's quite a challenge because as a concept, ESG is quite a broad and amorphous concept. But there's a general consensus that what we're talking about is three aspects of corporate behaviour, where there's now an overwhelming, irresistible, and universal demand that behaviour must change and improve. And that's to reflect modern values and ethics. And in the case of sustainable business practice, it's a case of addressing the urgent and existential threat presented by irreversible climate change. As a lawyer in a commercial law firm, I can assure you that ESG is absolutely at the top of the agenda of the board of directors of all of our corporate clients. And there's a number of reasons for that. Firstly, there's a proliferation of legislation and regulation, so non-compliance is not an option. But it's also a reflection of the inexorable rise and influence of social media, which is highly effective at immediately punishing perceived unethical behaviour by corporates, which comes to light. The reputations, profits and share price of companies can now be damaged in tweets rather than weeks. But it's also a reflection of the more enlightened views of the senior management of corporates and their major shareholders, such as pension funds, who are socially responsible and want to do the right thing. The approach I'm going to take is to summarise at a high level all three components of ESG. I'm going to look in particular detail at environmental, because that's where some of the most significant developments have occurred. But I'm also going to quickly look at S. S is for social, and G for governance as well, because it would be remiss not to at least touch upon those. So first of all, S. S is for social, and what this really reflects is demands for social justice and the protection of human rights, and in particular labour rights. So what we're looking at here are objectives including the eradication of modern slavery and child labour, the provision of healthy and safe working environments, fair working terms and conditions including equal pay, and limiting working hours and paying living wage. It is also sometimes taken to include the elimination of discrimination and the promotion of diversity in all its forms. Now, disputes in this area are generally resolved in employment tribunals and the courts, as they have been for many decades, and most jurisdictions have stringent and developed legislation to address these issues. But one area in which it's anticipated there will be a significant rise in disputes is in the context of enforcing ESG clauses in commercial contracts, and in particular international commercial contracts. A feature of the increased focus on ESG obligations is that companies are now judged not only on their own behaviour, but also on the behaviour of their subcontractors, such as manufacturers, suppliers and distributors. And as a consequence of that, there's an increased focus on developing and including ESG clauses in the boilerplate provisions of commercial contracts, which require that subcontracts assume ESG obligations. There was a recent report by the ESG subcommittee of the IBA Arbitration Committee, which looked at this issue, a report on the use of ESG contractual obligations and related disputes. I've got a copy here. It's quite a lengthy document. I commend it to you. It's quite a thick document. That's double-sided. I'm very sustainable. But what that covers, it sort of looks at the sort of ESG clauses that are now being developed and what the implications are. In particular, there's something called the Chancery Lane Project based in London, where lawyers have come together to develop and draft clauses that can be used and inserted into contracts. Examples of these sorts of clauses include clauses in supplier contracts requiring that they meet the requirements of employment legislation, and often what you'll see is the buyer including in the contract and appending their code of conduct, which sets out certain minimum standards of employment they expect the supplier to adhere to. And this is particularly important in the case of, for example, fast fashion supply contracts with their suppliers in places like Bangladesh, where this is a particular issue. In terms of environmental, clauses are now being developed to require suppliers and other subcontractors to report on their carbon footprint, because for the purposes of drawing up and calculating the buyer's carbon footprint, it needs to take into account the carbon footprint of its suppliers. So it's important that that data is provided, and it's important that that data is accurate and verifiable. As part of the IBA report, a survey was conducted of in-house counsel in major corporates. And that survey suggests that the expectation is that many, if not most, of the disputes arising in respect of ESG clauses are likely to be resolved through arbitration. And that's because the respondents were asked to indicate, in order of importance, the most important factors for them in determining the dispute resolution forum. And for ESG disputes, the number one factor for corporates was confidentiality. And that may come as no surprise because, as I've mentioned, in the field of ESG, reputational concern is a major issue for corporates, and arbitration is a process that can provide that confidentiality. Interestingly and slightly bizarrely, the second most important factor identified by respondents was transparency. Trying to reconcile that between the two is very difficult. The best I can do is they probably recognise that transparency is very important, but realise that to their employer, confidentiality was trumps. I'm now going to move on to governance. G is for governance, and what this is generally treated as referring to is compliance with anti-bribery, anti-money laundering, and sanctions legislation. As non-compliance in this context will almost invariably give rise to criminal liability, it's an area in which, unsurprisingly, the overwhelming majority of companies and directors take compliance very seriously. In terms of disputes, what you're generally looking at is prosecutions by the prosecuting authorities where the allegations of bribery have arisen. The modern trend is for cooperation. So prosecuting agencies now look to work with big multinationals. And so deferred prosecution agreements have arisen. And basically what they are is the prosecutor does a deal, and in return for corporates whistleblowing and reporting activities they've discovered and agreeing to remediation, prosecution is deferred. There's also a rise in sanctions-related proceedings and litigation arising from events in Ukraine. That was the subject of the last session, so I'm not going to go into detail on that here. In terms of the corresponding ESG clauses in contract, for many, many, many years now, it is boilerplate clauses in contracts to include provisions such as a warranty, whereby both parties warrant that they have complied with anti-bribery legislation and sanctions legislation. There's an obligation to continue to do so, and invariably that's backed up by an indemnity to indemnify the other party for any financial losses if it has been engaging in bribery or corruption. But in terms of those sorts of clauses, if a company ever needs to consider enforcing those sort of clauses, it's generally already too late. There's a degree of overlap between ES and G because another example of governance is greenwashing claims, and these are very much a trend in ESG disputes. What we are talking about by ESG claims is claims against companies or directors to hold them to account for making false and misleading claims in respect of their ESG credentials. And those misrepresentations might be made in filings made by listing companies, for example, with the Securities and Exchange Commission in the US, or in companies' annual accounts, or in advertising. And just to pick out a few examples of this, the Advertising Standards Authority in the UK banned a series of adverts by HSBC because they were misleading. In those adverts, HSB was trumpeting that it invested $1 trillion in climate-friendly initiatives and helping clients meet their client targets, but the ASA found that the adverts were nevertheless misleading because they omitted to mention that they are one of the biggest funders of fossil fuels in the UK. Another example, this time in Germany, Deutsche Bank's investment arm, DWS, was accused of inflating its ESG credentials in its 2020 annual report. And its global head of sustainability claimed she was fired because she'd objected to inconsistencies in the bank's public statements. There's an ongoing investigation by German and US regulators, and following the announcement of the investigation, there was panic in the market and there was a significant drop in the share price of Deutsche Bank. There are other actions in this area which are linked to greenwashing are securities fraud transactions where claims are brought by shareholders. I'm not going to address that because those are going to be picked up by another member of the panel. But moving on to E. E is for environmental. And in that context, what we're talking about is claims concerning harm to the environment. So this covers class actions, typically against oil majors or mining corporations, often seeking damages for harm caused by pollution or contamination events. But the most recent and exciting developments are in relation to climate change litigation, which, like sea levels and global temperatures, is on the rise. According to the Grantham Institute's 2023 Global Trends in Climate Change Litigation Policy Report, and that's not easy to say, around 2/3 of climate-related cases have been filed since 2015. So between 1986 and 2014, approximately 800 cases were filed. But between 2015 and 2023, over 1,500 cases were filed. And looking at these cases, they generally appear to have one of two different primary objectives. First of all, there are claims which have as their primary objective, putting pressure on governments and carbon majors to take a more aggressive approach in their plans to transition to net zero and ultimately ensure that the commitments assumed in the 2015 Paris Agreement are achieved. And these claims have the following features. They are typically strategic and high-profile pieces of litigation brought by NGOs, non-governmental organisations such as Client Earth, Friends of the Earth, and Greenpeace. Secondly, the remedies being sought are typically declarations confirming the existence of legal obligations to meet net zero targets, and injunctive relief requiring that policies and plans be amended so that they are more ambitious. So the focus is very much on demanding action is taken so that targets are met and irreversible damage to the climate is avoided, rather than seeking damages or compensation. Other features, the claims are well developed insofar as there have been a number of judgments in different jurisdictions which reach similar conclusions on similar causes of action. And the claims have all been brought in national courts. Now, one well-known example is the trailblazing case in 2019 of Agenda Foundation and the State of the Netherlands. And in that case, the Netherlands Supreme Court ruled that the Netherlands government was breaching its duty of care to Dutch citizens under the European Convention of Human Rights. More specifically, the court found that by failing to pursue a more ambitious greenhouse gas reduction target for the end of 2020, the state was in breach of Article 2, the right to life, and Article 8, the right to a private and family life. And there have been similar cases with the same result in France, the UK, and Germany. In February 2021, the Notre Affaire 2 and others, and France, a case often referred to as the case of the century, in that case, the Paris Administrative Court held that the French government was liable under French and EU law for taking insufficient action to meet its commitment to reduce greenhouse gas emissions. And closer to home and more recently, in Friends of the Earth and others versus Secretary of State for Business, Energy and Industrial Strategy, the High Court ruled that the UK government's net zero strategy was inadequate and that the plan had to be updated to provide more granular data demonstrating precisely how the proposed policies would ensure that the 2050 net zero target, which was set in the Climate Change Act 2008, would be met. The plan was updated. A new March 2023 carbon budget delivery plan was produced in March 2023, and that plan is also now being challenged by judicial review by Friends of the Earth and Client Earth. That type of claim has now also been brought directly against the carbon majors themselves and their directors. In May 2021, in the case of Milieu Defensie and others and Royal Dutch Shell, the Dutch Hague District Court ordered Shell to amend its corporate policy to achieve CO2 emissions reductions of 45% by 2023, as against 2019 levels, for both the Shell Group and its customers and suppliers. That was a class action, Like the earlier claim against the state, it was based on breaches of Article 2 and Article 8 of the European Convention on Human Rights and a duty of care under the Dutch Civil Code. Okay. In the UK, and another type of, and then to give you another example of the type of claim, where we see objective of trying to ensure that carbon reduction targets are met, are judicial review challenges made against the decisions made by government to approve specific projects which would increase greenhouse gases. And usually those sorts of judicial review proceedings are based upon planning legislation. For example, by challenging the veracity of environmental impact assessments. And one example of that is the challenge brought to the expansion of Heathrow Airport, brought by Plan B and Friends of the Earth. The other primary objective of climate change litigation that we see is to seek substantial damages to compensate claimants for the costs of dealing with the impact of climate change. These cases also share a number of features. Firstly, whilst NGOs often help organise and support the claims are unsurprisingly those people and entities directly impacted by the consequences of climate change. Substantial financial compensation is sought rather than injunctive release. And again, these cases are brought in the court. But one feature of these cases is they are all in the very early stages. None of them have reached judgment on the merits. One particular interesting example in this context is a case going through the German courts, Liuer and RWE. That's a claim by a Peruvian farmer against RWE, Germany's largest electricity producer. And in that claim, the claimant is seeking damages to meet the costs of setting up flood protection to protect his local community in the town of Juarez from flooding, which is likely to be caused by the rise in the level of a glacial lake resulting from the melting of mountain glaciers. Now, what's particularly interesting about that case is the nature of the causation arguments. It's contended that RWE knowingly contributed to climate change by emitting substantial volumes of greenhouse gases and is therefore partly responsible for the imminent threat of flooding. And the claimant is seeking damages representing precisely 0.47% of the cost of building the flood defences on the basis that it's estimated that RWE was responsible for 0.47% of global greenhouse gas emissions since the beginning of industrialisation. That case was originally struck out at first instance, but then it was allowed in the German appeals court, and it's now proceeding to trial. Now, this is a potentially very important case because if it succeeds, it could establish a basis for bringing potential claims against every carbon major, creating what litigation third-party funders and many climate activists would regard as a claims nirvana. And that's because every year we see an increased frequency in major adverse extreme weather events. Those events invariably lead to substantial property damage and substantial financial losses. And I finish. I'll just 3 minutes. And so hypothetically, we could see mass tort conduct claims on an annual basis. And the imperative and the motivation to bring those claims is only likely to increase because as there are more events, those sorts of events will become uninsurable. The question, now those cases are likely to pursue, at the moment, would have to be pursued in the courts. But the question arises whether they might be, one question that arises is whether those claims should really, or might more properly be brought at an international level. And there's two real reasons. One reason for that is the following. It seems inequitable that in this context that claims could be brought against a handful of carbon majors on the basis that they are headquartered or have their assets in jurisdictions which recognise these sorts of claims. Whereas if we were looking at it more logically, the view would be that there is a collective responsibility amongst all of those responsible carbon majors. And so it would be more appropriate for there to be proceedings which all of those entities are involved with other stakeholders. stakeholders. There is no international equivalent of Civil Liability Contribution Act. And so creating it's a global issue. It requires a global solution. And I'd suggested to you that only international arbitration can provide a multilateral dispute resolution forum for resolving that type of issue.
Thank you, John. I think we won't be able to address questions to John right now. And passing on, because one of the things that you touched was the fact that, the increase in number of disputes related to environmental issues. And one report or one article that was published by Bloomberg Law stated that right now, environmental disputes are around 1,400, whereas governance 900 and something, and social even less. But because we are focusing so much, and we are seeing such an increase in, in climate disputes, I think it's now the great opportunity to hear from Alison, from her experience relating to these disputes.
Well, thank you for the invitation to be here today. Thank you for the very kind introduction. I'm delighted to be here today with you all and talking about these interesting issues. So I'm going to pick up the baton briefly by delving a little bit deeper into the legal framework of international arbitration, particularly investment arbitration, and to think about how that fits with the issue of climate change. So, as we all know, arbitration depends on the consent of the parties, and all the more so where one of the parties is a state, arbitrating with a private person or a company, or in some instances another state. So, of course, international arbitrations happen in a framework of consent, given through occasionally contract, by far more often in a treaty, whether that's a bilateral investment treaty or a BIT, or a multilateral treaty, such as the Energy Charter Treaty, the ECT. Now, just stepping back for a moment, as a matter of history, that framework, of course, stems from post-war work, which led to the establishment of ICSID and the World Bank, and then model treaties and concluded treaties from the 1970s onwards. And I mention this timing just so that we can think for a moment that, of course, climate change was not, when the system was being set up and the basic architecture was being built, climate change was not on anybody's agenda. So fast forward to today, and the system of investment law, for many different reasons, has been going through what some people have termed a crisis of legitimacy for some years now. There are some 3,000 bilateral investment treaties in the world, along with key multilateral protections, such as the ECT. For many years, we've seen arguments that investment arbitration is a secretive process which lacks legitimacy and puts the interests of big business above those of communities. And those points have been put strongly by critics of the system. And I think that what we see today is that climate change is really a lightning rod for those concerns. Right or wrong, there is a perception and there is criticism of the system, the treaty-based system, which is perceived by some as tying states' hands, particularly when it comes to regulating to tackle the climate emergency. And I think that if the system is perceived, rightly or wrongly, as I say, perceived as inhibiting the ability of states to tackle climate change, then that's a really serious threat to the future of the system, because there is no way that states are going to support a system which, when their populations in particular feel that this is detrimental to the state's ability to tackle climate change. And we see this as an example. We see this in relation to the Energy Charter Treaty, which was actually conceived of as energy source neutral. It doesn't actually bake in a preference for fossil fuels or renewables. And the biggest users of the system, the biggest category of parties who've arbitrated against states under the Energy Charter Treaty have in fact been renewables investors, and staggering numbers of claims against Italy, against Spain, as you know. But despite that, and despite an ongoing reform process that's been initiated by the Secretariat of the Charter, European states, as we see in the news, are just walking away from the treaty in their droves. There's essentially a mass EU exodus of the treaty. And I think this is quite an interesting case study, because I think it shows that if any treaty framework becomes seen as tying states' hands on climate regulation, then states won't support it. And support for the ISDS system, as I mentioned, was fragile already. So against that background, what is to be done? A couple of suggestions. First, states can, of course, robustly defend cases by investors who've lost out, to put it simply, in the face of climate-friendly regulation. States can robustly defend those claims under the existing treaties, so the old-style treaties that were following the model that the first generation, as we call it, follow the model of the initial crop of investment treaties. And the language of those treaties is notoriously open-textured, and the amount of ink that has been spilled on the meaning of the words fair and equitable treatment, I think, couldn't have been foreseen by anybody, whoever drafted any of those treaties. But I would also argue that that can be a strength. So, for example, what legitimate expectation does a fossil fuel investor have in this day and age that there may not be regulation that impinges on their investment? So obviously there are challenges about different arbitral tribunals in their silos, deciding what fair and equitable treatment requires in climate regulation context differently. There's obviously problems of consistency, but I do think that there is space in that open-textured language for states to regulate, and for that potentially not to give rise to huge damages awards. Second, of course, states could amend their treaties. So amendments could make it expressly clear that the treaties don't prevent regulation to tackle climate issues. There's an ongoing process of reform here by UNCTAD, the UN Trade and Development Agency, and others. States are amending their model bilateral investment treaties to cater for this. And I think that's a very interesting process because it strikes a clearer and more foreseeable, perhaps, balance for the investor as to what scope the state has to change the goalposts after they make their investment. But also, I think, coming back to the sort of legitimacy issues I touched on, I think treaty amendment also has a sort of communicative role to the public at large in making it clear that this is not a system that is hostile to measures taken to tackle the climate emergency. I think the final point that I would touch on is that cases have to be conducted, whether they're under old treaties, whether they're under amended or new treaties, regardless of what the content of the law is that they're applying, they have to be conducted procedurally in a way that gives the process legitimacy, both to the parties, crucially, but also to the public at large. That doesn't necessarily mean full public participation, doesn't necessarily mean full transparency, but I do think that that procedural legitimacy is important here, and I know that Conway is going to touch on some of those issues when he gives us his thoughts shortly. I think I'll stop there. Perhaps we can pick up on the Portuguese children later on if we like, but I want to make sure, because they are fantastic, but I want to make sure that we have plenty of time for discussion and everybody's thoughts.
Okay. I don't know if you want to address any questions right now, or if we are good to...
Let's should have had the question.
Yeah. Well, I don't know if anyone has one question already, but from, picking on your point, Alison, one of the questions that, we could have is like, is the position of states when they are when they will be reviewing or are reviewing their treaties, and this is something that it is a challenge, and it's something that has been required for several reasons. This one even more, but the perception also for or how the states will balance the perception of being an investor-friendly state when they have a treaty that gives that much power to the state, for instance, to tackle these climate issues for investors. It is undeniable, the forces that are here. There were some expectations that the companies or investors would tackle or would be easily would address these issues with their investments, but now what has been realizing is that no, we will still need fossil fuels for much more time than expected. And if suddenly we start having, states amending these treaties and changing their positions and saying, okay, you are coming to invest, but there's something we can do. What's the message that it's is sending to the businesses and to investors in general?
Well, I think the answer to that partly depends on the starting point. And I think if you step away from the law and you look at the science, it pushes you in a particular direction in answering, in thinking about striking the balance between investors and the state's right to regulate. Because when you look at the science, and we're on the eve of COP28, yeah. When you look at the IPCC's reports, when you look at the extraordinary and rapid cuts in carbon emissions that the world needs to make to keep, 1.5, I was just in Strasbourg in September and we were arguing on the basis of a huge amount of science that 1.5 degree, any temperature increase above 1.5 is irreversible, disastrous consequences for the planet. We are at around 1.2 and again, already disastrous consequences. So when you look at that and you look at the extraordinary depth and rapidity of the cuts that need to be made from a scientific, because when you step away from the law and you step away from the economic issues and you just say physically how much carbon can the atmosphere absorb, a lot less, hugely less. Some figures say, 60% cuts over the next few years. So when you look at that, a scientist would say there's no space for worrying about too much about whether your jurisdiction is going to seem investor friendly and you're going to hurt the feelings of fossil fuel companies, etc. If you're led by the science, you just say, well, states under international law have a huge range of obligations to essentially save the planet, and that means bringing the fossil fuel reductions down so dramatically that it's going to need really stringent regulation, and that'll have an impact. And one would hope the reputation of states is improved by that. But when we're talking about, Conway was involved recently in the ITLOS advisory proceedings, and there are states there who are fighting for their very survival and quite credibly are not going to survive. And when we look at it from the science, when we look at it from the sort of existential challenge that, say, small island states face, I think states are going to have to be, I say this as I represent lots of investors who get hurt, upset when there's regulation, but states are going to have to be tough. I think because it's an existential threat to the planet, and in that context,
public interest involve everything.
Yeah.
Okay. I think we will pause a little bit with Alison, and now it's Arthur.
Sure, my pleasure.
That will touch on the arbitration and governance issues.
It's always difficult to talk about something that I'm not the most specialist in, which is climate change, especially after so eloquent presentations. But I'll try to tackle 3 different subjects at once. Wish me luck. So I'll talk about climate change, securities disputes, and arbitration. I'll divide this presentation in 3 parts. I'll begin talking a little bit about shareholder activism. Then I'll explain what shareholder activism can do for climate change. And at last, I will tell you where shareholder activism and arbitration will meet and overlap. And whoever gets this question right, I will buy you a drink afterwards. I'm sure Joaquin will get this right after his presentation in the earlier panel. So what is an activist shareholder or an activist investor or an ethical investor, as some people call? Well, an activist shareholder is someone who's willing to get their money, buy a chunk of shares in a listed company, and leverage his position to influence the management of the company towards a direction, whatever it is. And very often you hear an activist investor, an activist shareholder, talk about increasing shareholder value. And increasing shareholder value is music for the ears of all the other shareholders, because minority shareholders love to see their shareholder value increase. And it's also a bit self-serving because they are investors, so they are increasing their own investment. But shareholder activism is not always driven by financial returns. There are many examples, and these are not new examples, like for decades, nearly a century, of religious groups, public pension funds, labor unions that organize investment funds, and they buy shares in listed company, and they try to influence this company towards a direction that very often has no financial incentive, no economic benefit. It's really a social agenda that they are pursuing. And I think it's fair to say that, I don't know if I can call it a trend, but I can certainly call it a reality, because there are plenty of examples. There are investment funds that are driven by ESG and climate agendas. I picked one example to tell you here, which I think it's very curious, because it's a very small fund that may cause a major disruption. So a few years ago, a fund called Engine Number One, which is a fund that manages $250 million of assets, which may sound like a lot, but it's, in this world, it's not a lot. I wish I had this in my bank account, but I chose the wrong profession, I'm afraid. And they bought shares in Exxon. So just as a comparison, Exxon has a $250 billion market cap. So it's a very tiny, and they started to pursue sustainable agenda, if you can call it, and they wanted to replace 3 board members at Exxon's board. There are 12 board members at Exxon's board. And they managed to persuade 3 other funds, Blackstone, Vanguard, and State Street, that, I don't know if you can call them ethical investors, but at least they are more ethical than others. And these guys, they have together 20% of Exxon, which is a lot. So this tiny fund managed to elect 3 board members to Exxon. So this is an example of shareholder activism working. And what's beautiful about this, I don't know, at least I find it interesting, is that no lawsuits were filed for this. It was just a persuasion in shareholders meeting that convinced these other shareholders to vote with them. But what exactly do activists do? What are the strategies? We saw this example. I think it's an interesting strategy. I would put this in mid-level aggressive, in a level of aggressiveness. An activist may have a little bit of a more compromise agenda. They will call the board. They'll send letters to the board. They will try to set up a meeting. There's a lot of behind the scenes, and in my experience, which I think it's limited, it's a Brazilian experience, these things work. I think sometimes you'd be surprised that people will do what you want if they like you, and if you are not trying to shame them publicly. I think this is a very useful and a very effective strategy. But as unfortunately everyone knows, those diplomacy sometimes fail, and then you have to move to a little bit more aggressive. And one mid-level aggressive would be threatening or trying to replace the board, the management, which is the example I gave. And you get to the higher levels of aggressiveness, then funds will try to shame the company publicly. And John mentioned the power of social media, and this is very used in these strategies. And ultimately, they will litigate an issue, and could be a breach of fiduciary duty for greenwashing. There's a role of a range of options here. And so what shareholder activism could do for climate change? I think shareholder activism is something that has existed. Some people claim that since the 19th century, but I think it really picked up after the 1929 crash in the New York Stock Exchange and the 1930s securities regulation, and it works. Actually, activist investors have, in a number of occasions with different agendas, successfully influenced a company towards one direction or the other. And so, I think this is if shareholders that view climate change as an important issue organize themselves and buy shares in listed companies and start to act to influence management, a lot of companies will cave, will accept, and will compromise, because officers and directors usually like to keep their jobs. And by following the shareholders' instructions, they will more likely keep their jobs. And I think this is happening. John also mentioned the case that shareholders sued Shell in the Netherlands to reduce its carbon emissions. I think that's a very good example of a successful litigation, securities litigation on climate change issues. One thing that I find intriguing here is that shareholder activism and this securities pressure can be a double-edged sword. There's a very interesting case, recent, that Larry Fink, who is BlackRock's CEO, he was sued in the US for breach of fiduciary duties. The shareholders claimed that he was breaching his fiduciary duties because he was prioritizing an ESG agenda rather than profit. And Larry Fink won this lawsuit, but after that he was a lot more timid, a lot more shy in his disclosures and in his sustainable agenda. Now, where will shareholder activism and arbitration meet and overlap? Brazil, of course. It's I'm not buying a lot of beers tonight, but why is that? Brazil is one of the few jurisdictions, and maybe the only one, where shareholders' disputes are resolved by arbitration. And that's a very interesting feature of Brazilian securities regulation. Companies listed in the Brazil Stock Exchange must include in their bylaws an arbitration agreement. So virtually all securities disputes in Brazil are settled by arbitration. And why is this important for everyone else outside of Brazil? It is important for a few reasons. One, Brazil is big geographically, and most of the Amazon is there, for example. And I got this data online. I hope it's right. So the Amazon covers 6.7 million square kilometers, and for the English, it's roughly 28 times the size of the UK. So there's a lot of forest to be saved and protected. And second, Brazil is also economically big. It's the second largest economy in the Americas. It's the largest in Latin America. It's one of the 10 top economies in the world. And it has a very active capital markets. There's about 400 companies listed, and some commodities giants are listed there. I'm going to give you 3 examples. Petrobras, which we heard a little bit before, Vale, and JBS. So, if shareholders are willing to, pressure the management of these companies towards sustainable agenda, this avenue is available, is open in Brazil for this. We heard from Joaquin earlier in his presentation that Petrobras found a gigantic oil field in the north of Brazil. He didn't mention that's exactly off the Amazon River basin. So it's it's a very environmentally sensitive place. How will Petrobras exploit this oil field? Will any shareholder buy shares to pressure the management towards a more sustainable exploration? I don't know. Petrobras is not my client, so if any climate investment fund is hearing us here, I'll give you my card afterwards. And this is the end of my presentation. I was going to wish you warm holidays, but as I put these words into the paper, I felt that this was a terrible ending and a terrible prediction, so I'll give you another prediction. I think climate change, securities disputes will be a hot spot, a hot topic, and Brazil will be a hot spot for this. Thank you.
Thank you so much. I don't know if any of our co-panelists would like to address the question. I think Arthur still has time to answer one question at least. Would you like to address any? Otherwise, we will just try to comment.
I just had a quick question on just how our shareholders claims typically finance things.
That's an interesting question because litigation finance is available and is widespread in Brazil. And the way it works in Brazil, it's if you're moving lawsuit against a controlling shareholder for breach of fiduciary duties or for abuse of controlling power, it's a derivative suit, so the damages go to the company. So the law gives an incentive to the shareholder, which is a 5% reward. So if the tribunal orders £1 billion as damages, the shareholder will get £50 million. So it's an incentive for him to move the lawsuit. And the law also says that the lawyer who represents the shareholder gets 20%. So in this case, the lawyer will get £200 million. So as you can see, the Brazilian Congress can be very reasonable and intelligent in acting law sometimes. So usually this 25%, it's a potential receivable, and this will be sold. A portion will be sold to an investment fund, to a litigation fund, in exchange for the profits. Yeah. Thank you.
Thank you. Thank you, Arthur. I think we will now pass to Conway.
Thanks, Tara. I'm going to be the voice of skepticism in relation to ESG and arbitration. I'm an arbitration lawyer. I'm also an ESG lawyer. So as Alison said, I'm involved actively in climate change litigation before the ICJ and the International Tribunal for the Law of the Sea. I'm also heavily involved in sort of some of the bigger class action lawsuits in the UK courts to do with oil spills. And I'm on different sides of that. So I think I have a view of ESG disputes. And as you've heard from John and others, ESG disputes are a sort of broad and amorphous category. And so the question is, what does arbitration have to do and say about this category of disputes? And is this the future of these disputes being litigated? I think ESG disputes are being litigated in arbitration, so I won't debate that. What I'm questioning is the future of arbitration to have a greater role in the resolution of these sort of sensitive disputes. So we know, for example, as Alison said, that ESG issues come up particularly as defenses in ISDS disputes, and there's a great scope for states to continue to argue that their international obligations, including under the Paris Agreement, give them scope to impose measures which may otherwise constitute breaches of bilateral investment treaties. So that's already an established category of ESG litigation. But we do know that there's a big debate about counterclaims, and that is fraught and still developing. And it remains to be seen where that category of disputes will go until the new version, the new model BITs kick in, which won't be for some time because of very extended sunset clauses. There is also a great deal of scope for arbitration of ESG disputes, which are essentially business-to-business disputes. So as Arthur talked about, shareholder disputes are really a dispute about a shareholder and a company, and the various other disputes that John spoke about in the sort of supply chain industry, where you have a clause, whether it's a warranty or it's a due diligence clause, which requires that certain companies in the chain conduct due diligence in relation to the bona fides of certain representations to do with human rights, to do with labor rights, etc. So in the business-to-business disputes, when the ESG issue is effectively a question of contract, definitely, I think arbitration plays a role and has a very potentially helpful role to play. But there are other ESG disputes which have a systemic character, which I question whether they will or should be litigated in international arbitration. Because they're an amorphous category, I can't speak about them in any sort of way, but what I've tried to do is to identify what I see as certain common themes or features of ESG, this sort of systemic ESG disputes, and to think about whether those attributes make them amenable to effective dispute resolution through arbitration. So the first the features are as follows. The ESG disputes tend to be systemic in nature. The questions that are posed, even though they're posed in the context of bilateral disputes, they have a systemic character. For example, what is the legitimate role of the government in sustainability and climate change? That's a systemic issue. It may have a bearing on the rights and obligations of private parties or the rights and obligation of a private party vis-a-vis a government, but it also has to do with all of us. There is a question, ESG disputes also tend to have a mass character. That is, they tend to relate to incidents which impact large communities. And therefore, if justice is to be done, we would expect there to be a mechanism which allows the community as a whole, whether they be indigenous communities in the Amazon or coastal inhabitants in Peru or in Nigeria, that they can all access justice. And there's a real big question about whether arbitration is the right forum for those mass claims. As it relates to to climate change, we're going to be seeing greater scientific complexity in these disputes. There is a big issue about how you attribute blame for climate change. John spoke about the fascinating case in Germany of Leo and RWE, where the claimants are trying to use an emerging body of science called climate attribution science to get around the very problematic question of causation. But, it doesn't stand up to scrutiny if you think about it, because this one individual in Peru is going to RWE and saying, you should pay me 0.000% of my loss because you have been found to be responsible for 0.01%, whatever it is, of global emissions. But that means that presumably everyone on the globe can go to RWE and claim their 0.000, which doesn't seem to make sense. And that is what I think philosophers will call queue jumping, that, if that person, by virtue of bringing the claim, is able to go and get his piece of the pie, but someone in the Amazon or someone in Nigeria, Tanzania, Botswana, whatever geography you want, is also entitled to be in the queue, but because of access to justice issues, because of an inability to articulate a claim, whether financial or otherwise, they do not get to be a part of the queue. So there are real big issues there about whether that type of litigation is the right way of achieving climate justice. Another area of ESG disputes is that because of their subject matter, they tend to give rise to serious calls for transparency and access to justice. But we know the starting point of arbitration, certainly in this jurisdiction, is that arbitration is by default private. And that is implied in arbitration agreements. Once you have an arbitration agreement, as a matter of English law, it is implied that it is private. Now, of course, we have initiatives in the ISDS space, like the Mauritius Convention, but that actually, while very ambitious, hasn't really gotten off the ground. I think a total of 8 states have signed it. And so the default continues to be that it is private. And so the question is, and we've heard from John rightly, that the preference in ESG disputes is for privacy, right, because of the unsavory things that might come out. And so the question is, given the nature of the issues that are going to be debated, that will be decided in the context of ESG disputes, is privacy, is arbitration the right type of forum? And including in circumstances where the remedies are primarily ones to do with declaratory relief, what use is a declaration? What sort of leverage and public relations impact can these remedies have if they're only given in private? Access to justice is also a big issue. When an indigent litigant in Brazil or Nigeria or the UK go to court, they are accessing a public service. It may be flawed, but it's a public service. We do not bear the cost of our legal system. That is funded through general taxation. However, if we were to take ESG disputes to arbitration, then we all know, as arbitration lawyers, the bill. Who would fit that bill? For the fancy arbitrators, for the center, for the venue? Is it Geneva? Is it Paris? Who will buy the lunch? Very important in any hearing. But you see what I'm saying is that there are real cost implications which then impact access to justice. And so before we throw out the court system, we should be asking ourselves, how do we imagine an international arbitration system that really caters for this unique characteristic of ESG disputes? And certainly, going to arbitration still doesn't get you over some of the substantive legal hurdles, which tend to be an obstacle to gaining justice in ESG disputes. One being separate corporate personality, the point that it's really only the subsidiary that operates in the jurisdiction that you can really go after, but you cannot really pierce the corporate veil and get the pot of money that's in HQ in Europe or North America. And then finally, the fact that ESG disputes are simply politically sensitive. And whether we like it or not as arbitration lawyers, the system that we're committed to is under attack. We need only look to the recent questions raised by Mr. Justice Noel in the PD&I dispute about whether arbitration is even fit for purpose when looking at disputes which involve states. And that was a question about bribery, but that can apply equally to questions to do with climate, questions to do with the regulatory powers of states, etc. And so that's, I think, in the context of a commercial arbitration, That's not even to speak about the way that ISDS arbitration has been traduced. We have the special rapporteur, I think, on human rights and the environment calling it, I mean, the only thing left for him to call it is evil. Are we credible when we hold up the system as a sort of panacea for the access to justice issues that we have in domestic courts? And this is not even to speak about who the arbitrators will be, what values they will bring, and whether they're the right type of people to sort of strike the balance, the very fine balance, and the very sort of complex multifactorial decision-making that needs to be brought to bear in ESG disputes. So, I don't want to go any further, but just to say that, of course, there are incidental ESG issues that come up in arbitration, and certainly when there are ESG issues of a contractual or bilateral nature, arbitration is perfectly able to resolve those disputes. But I do wonder whether ESG disputes writ large, particularly those with a systemic element, are not better resolved elsewhere. And this is not to underestimate the serious challenges in domestic courts. There's a reason why we see claims coming to the United Kingdom. For example, the BHP, we talked about VII, it's being sued by over 200,000 Brazilian inhabitants in the UK courts, the biggest class action in this country. And class action proceedings are on the rise. ESG proceedings are on the rise. And part of why they come to the UK is because the domestic courts cannot be relied upon, or so it's said, they cannot be relied upon to deliver justice. But is arbitration the solution to that? Maybe international courts and tribunals international court is one solution, but I would also caution against that, because while Alison has been able to get a hearing before the Strasbourg court for the Portuguese children, anyone who's ever done an ECHR case knows that it takes ages, and that's held up as a success story for international courts and tribunals. But you send in an application, and 2 years later you get a one-page form which says your claim is inadmissible. So not giving much hope here, but just question the limits of arbitration and what it can deliver for ESG, and challenge us to think about the reforms and how what we have now can be perfected for what it was set out to do, which was to resolve effectively economic disputes.
Thank you so much, Conway. And let me ask you this in a very simplistic way. Are you leading us to think that from the E, S, and the G, probably arbitration fits for G disputes more than for E and S disputes?
I mean, I think G is. G generally. We always have to ask what goes into that bag. But I think, as a general matter, I think arbitration can be used for a lot of the sort of G disputes. And of course, I'm not saying that it's not couldn't be used for some S and some E, but it's the type. And for example, Judge Bruno Simmer spearheaded the drafting of some rules called the Hague Rules on Business and Human Rights, which was supposed to be a set of procedural rules, arbitral rules, to govern business and human rights disputes. Those have, to my knowledge, haven't been taken up yet, and I think that's because of the fundamental tensions between the mechanism of arbitration and some of its inherent features, and the features of ESG disputes.
Grace, I don't know how much time we have, but I think we could receive some questions from the audience, at least one per panelist, if possible, if anyone wants. Yes, Paula?
That's a good question, please, and I suppose this is directed mostly at Conway. I'm the last person to say that arbitration can't resolve disputes, but I think you made some very valid points. And yes, in a private context where you have perhaps co-venturers trying to decide who's going to pay, if they embark on the energy transition, that's a commercial question which arbitration can decide. But we're in a little bit of a legal vacuum when it comes to the border issues of duty of care and other ways of applying the various treaties that states have signed up to. And so I'm a firm believer that arbitrators apply the law rather than make it. So really we've got to wait until the various jurisdictions develop their own body of case law before arbitrators can even begin to apply. But I'm just wondering what your views are on that.
I think you're right, Paula. I think that, you know, there's a lot that needs to happen before we can get to a place where an arbitration could deliver anything useful in that space. One example is the Bangladesh Accord, which was a very unusual scenario where there was a big disaster in Bangladesh in relation to some fabric manufacturers. And what happened after that disaster, there was a horrific accident which caused lots of harm and death, thousands of garment factory workers. And what happened was the employers and I think trade unions all came together and decided on an ad hoc arbitration system that would oversee the application of certain international standards to those types of disputes. And it was used arbitration. A partner of my firm was one of the arbitrators, and a Casey from Essex Court was one of the arbitrators. So it could work, but that was a very unique set of circumstances. But I do think that that's perhaps where we can go in the future, but I do think that lots need to be done on this sort of lawmaking plane before we could get to something like that being applicable more broadly.
And I think to pick up on the Rana Plaza, the Bangladesh example that you give, Kunmay, I think one thing that was interesting about that was that, as I understand it, the company funded the system. So the company said, there's been this tragedy, we need to get to the bottom of it, and we need to have a system whereby if compensation is due to people, it's going to be adjudicated on and ordered. And so they made this ad hoc system and they funded it. So the people could come into the system, people who'd been affected or their families could come into the system, and there was this funded system which you'd kind of pre-funded, as it were, your opponents to bring their cases through this system. So it was quite a kind of unique, you know, the equivalent would be, you know, a state or a company pre-funding a class action against it. You know, it was probably the dramatic and awful nature of that tragedy and the sort of reputational harm as well as the loss of life that caused that. So it's very interesting, sort of that funding-wise, it was a quite unique situation as well.
It'd be interesting because, of course, companies have under the UN guiding principles a duty to provide a remedy, and it's a question whether they need to fund, they need to do something. I'm not sure many of my clients would agree that the duty extends that far, but that's a practical access to justice issue, which puts courts ahead of these sorts of arbitral institutions.
One question? Yes, Yasmin?
Just an observation. In the US, where corporations are extremely powerful at steering arbitrary consumer disputes into arbitration, they must pay the arbitration costs for both sides. And it's the same standard in employment arbitration. And it's usually driven by arbitration rules that impose that, but it's also to protect the integrity of the work. But I like the Rana tragedy example because it's really an example of you can fashion the tribunal you want. It's at the Iranian Islamic tribunal. It says that if you need a forum, you will create what you want, including the publicity. And I think it's great that this forum was created, but I think it's also to consider the context of their exposure if these companies were sued in their home states.
Would have been larger.
Where I'm not sure they really wanted to see that. And there seems some interesting developments in that.
Thank you. I think we have one more question there. Yes?
Yes, thank you. My question is for Alison. Alison, thank you for pointing out that really it was under the Energy Charter Treaty, which is perhaps 90% of the cases, they actually concern renewable energy claims, as opposed to the just general just perception. Actually, in most cases relate to the fact that the incentives were not honored. And therefore, my question is, I fully understand that there is genuine opposition to the ISTS from environmental quarters, but to what extent do you think that opposition has been actually manipulated by economic nationalism and populism that actually has a general problem with rule of law, and the state's reaction to ISTS is actually more driven by economic nationalism, but the environmental concerns are used as a legitimacy front to take all the steps that they are taking?
I mean, I think obviously on a broader level, we're in a period when multilateralism isn't necessarily doing so well. There's lots of challenges to that. There's lots of challenges to the international rule of law more generally. There are lots of states which are hostile, and I mean, including our own, where we sit today, has been hostile to a number, rhetoric about leaving the European Convention on Human Rights and things. The states are hostile can be hostile or can manipulate hostility or create hostility to the idea that there are these rules imposed from externally on the state, even though, of course, they're only just treaties that the state signed. So there's no real consent issue there at all. So I mean, I agree that can be part of it. But I think there is also the genuine, non-manipulative, we may agree or not agree with it, but I think there's genuine objection to some of so for example, to the ECT, there's a case going on in Strasbourg brought by various NGOs, I think Greenpeace, against a couple of states. And the argument is that it is a human rights violation through contributing to climate change and the human rights impacts of that for a state simply to be a party to the ECT. So I mean, we don't know how that's going to go. It may or may not be. It hasn't had an admissibility decision yet. But there's litigation like that saying the very fact that a state is party to this treaty is in and of itself a human rights violation. And you can see lots of legal objections to that argument. But to your point, I think it does show the strength of, whether we agree or not, the strength of genuine feeling that's gathered around these instruments, and particularly poor old ECT. That as far that and you will have seen in the room, I'm firmly of the view that the world needs to do a lot and very fast to tackle climate change. And I feel a bit sorry for the ECT, because I feel like it was designed to be neutral. There's a robust reform, it's very open to reform. Renewable investors are the big winners, and everybody hates it. So I think it's had a terrible PR problem for whatever reason.
Yes. I think we have reached our time. It's a very rich conversation. We could go on and on, but if we can take, I think we can take more questions from here than certainties. The issue, or the one question will remain: is arbitration fit for the purpose of ESG disputes, climate change disputes? Should it be solely, at the hands of judicial courts, considering one of the very important topics that Conway touched about, the access to justice? When we are talking about class actions, and when the impacts of the climate changes, are affecting so many people, who can get to the courts and who can have access to those claims? Another thing is that, and it started immediately, I think, with John, when he said that behavior must change, and ESG is not just an issue of ticking the boxes, but compliance. It is mandatory, and at least from the governance perspective, the board of directors are taking it seriously. It's not just, we are not talking anymore about they must. Right now, they are taking it seriously. Even if at the end of the day they still want their salary and they don't want to give up on their jobs. And very importantly, Arthur touched on the on the case of Brazil and how open it is, the market it is now for these governance disputes, and how the regulations and the states are looking into and opening the door for those disputes. Even if it is for economic reasons, lawyers winning and not, everyone winning, and it definitely brings the opportunity and that access to justice that we were talking.
If you can do the right thing and make money,
That's
nothing wrong, right?
I think this is why we all started studying law, because we wanted to do the right thing. And, I think well, at least for those that that used to dream about law and seeing some TV shows, it looks like we can do money and do right things. But let's move on. And finally, there is a challenge specifically when we are talking about renewables, investments, the biggest companies running the world and bringing money to the table, what to expect and what states will do, how the ECT will end up, dead or revive. I think we are close, and please a suggestion, next year we probably will have to continue this conversation, but we are now closing, and thank you very much for your contribution.